Okay, so we are going to be talking about the Supreme Court and their ability to exercise the power of judicial review. So now, judicial review, again, is the ability to overturn laws passed by Congress that the Supreme Court feels are unconstitutional. So two famous courts, they're named by the person who's the leader of the court, because the Supreme Court always has to pick one person as their leader. And for the Warren Court, that means it was led by a man whose last name was Warren. So the Warren Court was known for judicial activism. Activism means active. That means they're actively using their power to overturn laws, and they did it quite frequently. That's what activism means. As opposed to the Rehnquist Court, again, that means the leader of the court's last name was Rehnquist. They limited government by exercising judicial restraint. That means they did not use their power very much. Brown versus Board of Education, Topeka, which was a Supreme Court decision handed down in 1954. And that's where they decided that separate was inherently unequal. They had Brown was a family, last name of a family, where a little girl had to walk 21 blocks to her school because the white school 7 blocks away was for whites only. 21 blocks, that's a long walk. There was no buses to help her get to school. Not that it would have mattered, because there was a school a lot closer to her. Imagine if you had to go, if you lived in Fontana, and then you had to go to school all the way in Rancho. I mean, even though you live in Fontana, and you had to walk instead of going to the school that's just, less than a mile away. So it was unequal, and the court finally realized this, and the impact is going forward that segregation was banned. Segregation means to separate. Desegregation means to unseparate, and that's what this did. This desegregated America. You could no longer legally separate races. You had to allow them all or none. Another important court case handed down in 1972 was Furman versus Georgia. Furman was convicted to die by the state of Georgia. He had received the death penalty. He thought that was unconstitutional because the death penalty was not applied to him fairly. And what he meant by that was others who had done similar crimes were not given the death penalty, but he was. In this case, he felt it was because he was black. But it really didn't matter about the race. The point is that others who'd done the same crime were not given the death penalty, and he was. Now, what he did was punishable by the death penalty. It wasn't that they had invented a new penalty for him. The point is if that penalty for that crime was death penalty, how come others weren't given the death penalty? And if others weren't given, then maybe he shouldn't be either. So that's what he was complaining about. And the Supreme Court upheld it. They supported him. They said, no, you can't violate his Eighth Amendment rights. His Eighth Amendment rights being no cruel and unusual punishment, no excessive punishment. Okay? So that's what is done. They could not prove that that it was done fairly. It wasn't done fairly, so Furman, his conviction was overturned. Gregg versus Georgia came a few years later, and this was kind of in response to Furman versus Georgia, because many states after Furman were afraid to continue to convict people to the death penalty, and it was because they weren't totally sure how to prove that the death penalty was applied fairly and consistently. They knew what the word consistently meant, but they just weren't sure exactly how to prove it, so they don't waste their time and effort convicting someone to the death penalty and then having that penalty overturned. So a lot of states were starting to rewrite their laws. So this court case was brought back to the Supreme Court to have them confirm that it was okay to have capital punishment. It was okay for states to decide to have the death penalty as long as it was consistent and fair, and they just reclarified themselves what exactly was consistent and fair. So after this point, States who wanted the death penalty could do it, and they didn't have to worry about their decisions being overturned, because Gregg versus Georgia is an example of the Supreme Court clarifying itself in a future court decision to help reinforce an earlier decision. Roe versus Wade is another Supreme Court decision that was handed down in 1973, and this is the most controversial Supreme Court decision in the last 100 years, if not in our entire history, because this has to do with abortion. And it was a very close decision, and it's been revisited numerous times, and it will most likely be revisited again multiple times in your lifetime, because it is just such a tricky area and is such an emotional topic that it just does not go away. And maybe it shouldn't. So the Roe versus Wade, before Roe versus Wade, most states, not all, but most states had laws legalizing abortion. So this court case was the first one that said that abortion cannot be made flat out illegal. You have to allow people to have abortions based on the 9th Amendment, which says the government can't pass laws that interfere with your rights, even if those rights are not in the Constitution. The government can't interfere with them. Now, they understood what that meant to just say you can't stop any and all abortions, so they did limit it. They said that after 3 months, the government can say no abortions. Okay, because at that point, now we're talking about something that is kind of acting like a real human being. Like that, it's really hard to argue with at that point after the first trimester. The first trimester, I'm not going to get into, is that a life? Is that not a life? That's a whole different debate for outside the classroom, maybe outside the school even. And it's a debate that you're going to hear about and maybe be involved in for the rest of your life, because this will keep coming up, because there is no perfect right answer to that question. You have to decide it for yourself. But the United States Supreme Court said you do need to decide it for yourself in those first 3 months, and not the government. The government will not decide for you. You will decide, and that's what they allowed here. And this killed most state laws against abortion. Now, as you can imagine, some of you watching this would feel very sad about that if you feel strongly against abortion. And many people in America do feel strongly against abortion, just as there's many who feel that it should be allowed. It should be up to the individual, not to the government. So Webster versus Reproductive Health Services was the Supreme Court's way of saying that, okay, you can't ban it, but that doesn't mean you have to force people to pay for it who don't want to participate in supporting abortions. So there was a Missouri law that refused to fund abortions because of 3 reasons. One, they believed that life begins at conception, as soon as that baby is made, that instant. They believe that unborn children have rights, and that public funds, tax dollars, should only be used if the mother's life is at risk. And the Supreme Court decision said that's fine. If the people of a state don't want abortion, they don't like it, they still upheld the right of women to have it, even if it's unpopular. But that doesn't mean that our tax dollars have to go to support it. So they made the decision that a state does not have to pay for abortions, because that's meaning it's forcing people who are paying in taxes to effectively spend their money on abortions if they feel that abortions are wrong. So you don't have to support abortions even if it's not illegal.